Welcome to the Law Shit You Should Know podcast. We're here to talk a little bit about the law
and a whole lot about nothing. Every week, we have a new guest to discuss current events, legal drama, and dive even deeper into
the Law Shit You Should Know. Hi, everyone, and welcome back to Law Shit You Should Know with Elina Santana
and Leslie Marenko.
And today we have Mr. Kai Jacobs with us today. Hi, Kai.
Hi, everybody.
Tell us what you do. Tell everybody who's listening.
Okay, my name is Kai Jacobs. I'm the owner and founder of a law firm called South Florida Business Law Group, and we help businesses when they have to go to court so they can go back to making money.
I love it. That's good. So what kind of clients do you deal with usually, Kai?
So we've got a variety of clients. We've got businesses. We've got large businesses, publicly traded, privately held, family owned, mom and pop shops, and then we have a lot of individuals. There are people who have business needs and business interests. The vast majority of what we do is based upon contracts, one form or another. Busted real estate deals, distributorship agreements, non-compete agreements, buy-sell agreements, asset purchase agreements. At the base of just about everything we do is some version of a contract. We're not niched down into one particular kind of contract. Contracts are contracts, and really it's about who gave what for what. And all of our lawsuits are really about one of two things: either a misplaced event in time, or two people disagree as to what one particular event meant.
What do you mean by misplaced event in time?
So there should have been something that happened on a particular date. Like I have one particular lawsuit where the entire dispute is about a 6-hour window of time. Was the contract formed in that 6-hour window of time, or was it not?
The formation.
Yes.
As opposed to the act that the contract was about.
Right.
Did you deliver my boat on time? Did I purchase whatever within as many dates? You're talking about, was it formed?
Was it even a contract?
Right. The entire lawsuit is about, was there even a contract?
Oh, okay. Got it.
Wasn't there a great case, the Lady Gaga with the dogs case? Right? Do you remember this? Do you know what I'm talking about? No.
Where she had the dogs kidnapped?
Yeah, the dogs were kidnapped, and then
What?
there was a whole question.
Yes.
There was a whole question about whether she had made a contract with the public about the reward.
Wait, tell me.
Okay, so Lady Gaga had some, I don't remember what her dogs were. Lady Gaga had some
Two French bulldogs.
The French bulldogs.
Very expensive
Those
French
things are
bulldogs.
so ugly.
Hey, I got
so ugly, those dogs. Okay, anyway.
They're so ugly, they're cute.
And they're so ugly, they're expensive, is what it is. Like Mark Anthony, he's so ugly. You can find him attractive. I hear.
Anyway. I hate male directing.
Anyway.
So she had these cute little French bulldogs, and they got stolen, and so she put out a reward. I don't remember how much the reward was for. Something obnoxious because she's Lady Gaga.
It was like $25,000.
Yeah, it was a lot of money. It was well into the 5 figures.
I expect at least $20,000 if I return your dog, Lady Gaga.
Okay, well, the point is she offered a reward, and then the person who stole them tried to return them to claim the reward.
Right.
And so the whole question was whether or not she had formed a contract with this woman, whether this person who was dealing in unclean hands, as we call it, actually is able to collect this reward.
But the underlying presence of that contract would have been an illegal act. So
correct. So it would have been void ab initio.
Okay, I mean, come on. Yeah, all right.
But it went. I think it wasn't just a one.
But how do we know that she stole it? How do we know she stole the dogs?
Well, I mean, I think she got caught, and then she's like, "Okay, here's a dog. Now
give
me my money.
Give me my money."
Was this in Miami-Dade County?
No, but it could have been.
Definitely could have been.
By the way, if you want to make a quick $10,000, there's a missing cat in South Miami, and they've got a reward sign up for $10,000.
Is that the cat that's suing me? Okay, it's a different podcast. What is happening here?
There's an orange cat.
Okay, so let's talk contracts. You said real estate. That doesn't happen, right? The real estate issues in South Florida.
No, Fraud Lauderdale? No, never.
Fraud Lauderdale. I like that.
I know.
Tell us about that, Kai. What kind of contract issues do you see with real estate that end up with you? Because you're not a real estate attorney, right?
No, I don't do closings.
Right.
But when they go sideways, they land on my desk.
Right.
And in the last few years, really in particular since COVID, when all of a sudden there were waves of people moving into Florida, and those of you who've tried to buy a house in the last 4 or 5 years have found it to be impossible. So prices have escalated, and this happened for a while there, a few times a week. It still happens with a lot of frequency, I suppose. So you buyer sellers get into a contract, and the buyers will place their initial escrow deposit, and depending on the value of the house, it's $5,000, $10,000, $20,000, $25,000. Sellers find a week later somebody else who wants to buy the property for a lot more money. and they say, hey, I found another buyer, and they
That's
simply
for you.
and so they'll terminate the contract, and they'll sign the little cancellation and release form, and they'll say, I'm happy to give you your escrow money back, now go away, and they think that they're going to get away with it.
They're so kind.
Well, and then there's
I'll
some
have to
people
give
who
you money
think that
back.
they're being generous by saying, oh, and of course I will pay all of your closing costs.
Right,
and,
right.
send me that. And so they think that they're just going to give back escrow money, give away a few $1,000s. But it's now, the case law has not really evolved very much, but most people haven't paid a lot of attention to it. And what the measure of damages is, if you're the buyer, you say, well, wait a minute, I was going to buy this house. Now I got to go up the street and I got to pay for something else.
Right.
So the traditional model has been, oh, well, I can go pay for this other more expensive house and I will sue you for the difference in value. But that gets into a very messy, expensive proposition.
I was going to say, who's paying all the attorney's fees in this shit show?
Well, you're litigating, and of course we'll get into prevailing parties later
Okay.
on, but you're still litigating, well, I don't know, does it have the same number of bedrooms? Well, is the
Right.
roof in the same condition? Does it have a septic tank? Is it on sewer?
But I mean, correct me if I'm wrong, but you can get out of a real estate contract at certain intervals, or if you do certain things wrong, right?
Yes, but usually those things are spelled out in the contract.
Right, correct.
So if
the appraisal sucks.
Yeah,
The
correct.
inspection's trash.
well,
Whatever.
so there's, in a lot of these agreements, there's a financing contingency.
Yes.
Okay.
If you
Right.
don't end up qualifying for contingency, that's it. The deal is considered dead. But that's stated on the face of the agreement.
Right.
If the property doesn't appraise, the contract's for $600,000, but the appraisal came back at $560,000. You have the option to work it out buyer and seller, but if you don't, then the contract dies. You
Right.
get your money back, everybody goes away. This is different. This is, I've hired
agreed.
movers, I've quit my job, and the seller says, hey, thanks, but these
This guy
people
came-
up the street are showing up with a briefcase full of money, and they're going to give me more money, and they don't need any contingencies to close, and I get to take this money and go home tomorrow. Goodbye. So in those instances,
And they're stupid enough to say that.
Well, I was about to say, it's just a situation where the person's dumb. I mean, frankly.
Because Elina clearly would just blame it on the one termite she just
Absolutely.
found.
I'm like, I found the termite piece.
but that's great if you're the buyer.
Right.
If you're the seller,
Uh-huh.
what would your excuse be? So sellers come up with all
Oh,
kinds of
but
things.
buyers do all kinds of shit. Excuse me.
Well-
But they're late on crap. They ask for extensions that you don't have to give if you don't want to.
Well,
you
so here's what happens. You're right, and so sellers will often come up with some sort of
Sure.
excuse,
I could come up with like 10 right now.
and then the buyers end up not doing anything at that moment. They end up going along and buying another property, not moving.
Sure.
But all purchases and sales are publicly recorded.
Right.
They go on to the Miami-Dade County Property Appraiser's website in 3 weeks,
Sure.
and there's a deed to someone else. That's not that hard to figure out,
But
folks.
so maybe that guy didn't mind the termites. Look, I mean,
But they end up suing, and the measure of damages is not what I lost, which is, well, it is the measure of what you lost. It's, I had to pay for this, I put in escrow money, which you were gracious enough to give back. Maybe you did or didn't give me back my closing costs, but you ended up selling to the new buyer for $80,000 more. That's my measure of damages. The measure of what
Really?
I could have sold that house for, I can now nail down on a date you in fact did sell it. So that, and there's a body of case law that supports it. I have convinced sellers to sell to my buyers a number of times because of that, and we've managed to stop a number of lawsuits from having to take place at all by telling sellers, you're going to have to sell to me. You can go sell to that person up the street, which may be what you're up to, and maybe it's not what you're up to, but if you do, this is what you're going to end up writing a check to my client for, not just escrow money. And that saved a number of deals.
I hear so many missed opportunities here. So,
Well, there's always missed opportunities.
Allegedly.
so for
What are we
everyone
talking about?
listening, if you got yourself out of a contract somehow, or someone got you out of a contract, you need to go check the property appraiser's website for the next couple of weeks.
Yeah.
This is what I've learned in this conversation.
If your seller all of a sudden decides that he or she or it is no longer going to sell to you, yeah, pay attention. Because
they just pulled one over on you people.
it's
I mean,
it's escalated in a way that like I'm prepared to put it like as a frequently asked question on my firm's website.
It's an FAQ.
Like I get this a lot.
Interesting.
Wow.
I mean, I know a lot of contracts fall through. I never really thought about that side of it though, like actually going back and suing. I feel like people find an excuse. I guess there are a lot of dumb realtors out there. Excuse me to the realtors, but there's a lot of dumb realtors out there.
This really isn't based on anything the realtor did or didn't do. What often happens?
Well, the realtor.
Who do you think brought that liar with the suitcase of cash?
Well, okay.
I mean, listen. So my husband has a realty, right? And I hear some of the things that other realtors, especially, will tell him, and I sit there like, why would they ever say that? Like, if you were a realtor, why would you ever come to
Like
someone
the
and be
emoji.
like, "Hey, look, we got $50,000 extra dollars, so bye." Like, are you dumb? Like,
Well,
there's so many ways people violate
Well,
contracts.
no,
I mean,
there
you
are.
can find legitimate reasons to end contracts.
There certainly are. I will say this though, in none of the cases that I've had to get involved, with the exception of one,
Yeah.
was this because the realtor encouraged the person to do it.
Okay. Well, all right.
Now,
okay.
that said, I just did get a case where by the time it got to me, the realtor had already been disciplined by the state.
Okay.
Oh.
And
But I hear you.
never happens.
I'm unfairly
Never
bashing realtors. I apologize to all
right,
the realtors.
you know, I'm
Like,
gonna say that phrase that everybody hates about lawyers. You know, it depends. You know, the circumstances of
I
your
got you.
case may or may not be different, but yeah, there are enough scrupulous and well-meaning realtors who
Okay.
I can tell from like the way, because we get the communications in the course of the lawsuit, and they let their clients know, tell them,
Nice.
don't do this,
Well,
don't do this.
Maybe not a good idea.
Meanwhile, all of this costs money. How do people even pay you for all this shit? Like,
I'm a very practical person,
Yeah.
and I want to know who's paying all of your. I know you're not a cheap guy, Kai. You are very sophisticated.
Kai is not free.
He is not free. He is not pajarito lawyer. Do not call him for pajarito things, or if you have no money. So, who ends up paying you, Kai, and to what extent is it worth it? So, there's $80,000. Back to the $80,000.
Right.
I mean, that seems like it might be worth it.
That's
But I don't
that's
know
a little
that,
bit
like,
of money.
10K would be worth
It's
it.
a little bit of money. Right. No, 10K is not worth shit, bro. Like, so, so I am also not pajarito lawyer, for the record. So, yes, Kai.
Okay. Let me start with an important qualifier. I am in fact cheap. I'm just not inexpensive.
There is a difference.
But that aside, so the standard form purchase and sale contracts used by the vast majority of real estate lawyers in Florida.
Mm-hmm.
It's a standard form. There's a Florida bar, there's a realtor's form, and it's an as-is purchase and sale. They all include a prevailing party attorney's fees provision.
Okay.
Winner takes the fee. I should also point out.
Cue the ABBA song.
I should.
I almost started singing there.
I should point out though that those agreements also have a what I consider to be a brilliant effort to stop that whole train from leaving the station, which is they have a mandatory pre-suit mediation requirement.
Okay.
That before you can sue, you must go to mediation.
Okay.
And I forget which of the two forms it is, but it's section 16B of one of them. And you know, you hire a certified mediator, so that conversation always remains confidential.
Mm-hmm.
A lot of those cases get worked out, and so yeah, before you spend $10,000, $12,000, whatever it takes to
Yeah.
recover $80,000, you go to mediation, and hopefully you spend a few hundred. And you know, the reality is in litigation in my world, the issue of attorney's fees, it's really a bargaining position. You know.
Yeah.
When people start talking about in settlements or judgments, I want my attorney's fees, I'm going to get my attorney's fees, that usually becomes the thing that kills the transaction or the deal or the arbitration or the mediation or the judgment negotiation. Well, we'll wipe out the attorney's fees if you just write me a check for the money you should have in the first place. And that's very often the way it ends up. But and some people play all the way to the end and they say, no, I've got a large attorney's fee award here I can get, and I'm going to go get it, and I don't care if I don't collect it. And the conversation then, you know, often is, oh, my client doesn't have the money, and you'll never get it. They're judgment proof. They'll file bankruptcy, and
Good luck with that.
it's the same thing every time. I mean, you know, we go to mediation. You know, I hear this conversation all the time. But what people who are buyers or sellers, who are looking at that scenario should always keep in mind is a judgment is good for 20 years.
Yeah.
So you may not have the money today,
It's a long time.
but you will have to say, I'm going to intentionally impoverish myself
For the
next
next 20
2
years.
decades in order not to pay you $10,000, $12,000, whatever dollars.
Yeah.
And that's not really a good way to live, because what very often happens
In poverty? No.
is
With everybody else holding all your money?
yeah, it's
That they steal from
messy,
you?
it's complicated, and it just and then you turn it over to judgment collection lawyers who do this stuff on a contingency.
Absolutely.
Right.
And so, they'll just open the floodgates and come after you. So I don't ever tell people, well, you'll never collect the money, because that's not really the way to go about it. It doesn't really work that way.
Yeah. Yeah.
Interesting.
And that attorney's fees conversation is always something that's so important in every negotiation and any, do we sue, and in a consult, I imagine, in a strategy session, looking at the case before they ever spend an obscene amount of money to go into litigation.
How does that work, Kai? I think you told us before we started the podcast today that there was some case you were working on or some judgment you recently got about
Yeah.
this. Tell us about that.
So I was representing a landlord. Significant amount of rented issue. This wasn't, a couple $1,000. It was a big home with a lot of money. And my client was owed a lot of rent. And as the case went on, I inherited the case. We realized we were exceeding the jurisdictional amount that the court was going to award us. So we asked the court to allow us to remove the case from county court to circuit court. The judge said no, she wanted to push it to trial. So we said we will voluntarily dismiss the lawsuit without prejudice, and we will refile in
Yeah.
circuit court. And the other attorney, who, smart guy, was aggressive, filed a motion, said, I am, and the magic words are, the prevailing party. We always hear this, the prevailing party statute, the
interesting.
prevailing party. I'm the prevailing party. And he came armed to his motion and the ultimate hearing with the general body of law that says, even if you dismiss a lawsuit without prejudice, you are the prevailing party and you are entitled to attorney's fees, even if the other side goes and refiles the action. And that's what we did. So they felt pretty good about their position. And
Interesting.
we went to the court and we pulled out the landlord-tenant statute, and we pulled out the standard form realtor's contract, which, by the way, which is why everybody in the world should use it. It doesn't say prevailing party. It says the attorney's fees go to the party that get a judgment or a decree in their favor against the non-prevailing party. And, they argued that that was splitting hairs. And, I'm not going to bore anybody with the deep, history and research of how these statutes evolved, but there are a few statutes out there that differ from this general prevailing party statement and make it very clear that you're not just quote unquote the prevailing party. There has to be some other condition that has to be fulfilled. Both the landlord-tenant statute and the standard realtor's contract in a lot of cases, and in this particular case, this lease, which is also the standard lease form, require that you get a judgment or a decree entered in your favor, and the judge agreed with us. And we relied on a case we were in the 4th district, and it's Ortuzar versus Foley was the case we relied on, which is a 5th district court, which is further up the coast. And it was exactly the same case. She agreed, she said there's no attorney's fees, and they appealed that decision. And they hired appellate counsel. We went through the whole dance again, and the 4th District Court of Appeal agreed with us. And they said, yeah, there are some other statutes, and based upon this authority, Ortuzar is now going to be the law of the 4th District. So now we've got 2 districts in the state of Florida that, if you voluntarily dismiss your lawsuit based upon your lease and the landlord-tenant statute, the other side is not going to be the prevailing party.
Very cool.
Super cool.
We just got the mandate handed down in that case a couple weeks ago, so that's now the final word on that.
Nice. What about the other districts? They just don't have any case law yet.
So the 5th agrees with that. Nobody else has exactly ruled on that.
Okay.
Now, it's possible that one day, one court will certify a conflict, and maybe the 3rd DCA will say differently. or the second, and it'll end up before the Supreme Court of Florida.
Right.
I don't really know what the U.S. District Court judges have to say about this, but they follow the general proposition that if you voluntarily dismiss your lawsuit under Florida state law, the other side is the prevailing party, even if that dismissal is without prejudice, and you refile your action.
Interesting. So the short answer, I think, to the question I started out with is
it depends. No.
It's about to say whoever loses the fuck is what this all comes back to. Essentially.
Well, so no, I mean, I get this all the time. People, when they call and they want to know about their lawsuit, they want to know what their range is. The question always comes, can I get back my attorney's fees? I want to sue for attorney's fees. And we follow this thing called the American rule. And America is sort of in the minority position in this. If you, depending on where you are in Europe, attorney's fees are just assumed. You lose, you're betting the farm.
And when you say American, you mean U.S., not necessarily all of. I'm sorry.
Yeah, no,
you don't mean Central America. You don't mean Guatemala.
It
means the Western Hemisphere.
I mean, I might. I don't know, but I don't practice in this
Alina,
country, so
I'm sorry.
It's the only America that matters.
But,
I don't know where you're going.
Again, hate mail directly to Leslie.
The American rule. We don't mean
okay.
But what they mean by that is the American versus either a European rule or some other. So in America, everybody bears their own costs and attorney's fees incurred in litigation.
Okay.
With two notable exceptions. If you have a contract that says so, which means the parties bargained for and gave consideration for the idea that, well, if we have to fight about this, and you can call it prevailing party, there are those words again, will recover his, her, or its attorney's fees. And or you have a statute that allows for the recovery of attorney's fees.
Sure.
Title VII, the
wage and hour,
the landlord-tenant statutes, and
the old first party. Sorry, guys.
Right, the first party. And now Florida has what's called mandatory reciprocity, meaning you can write into your contract, if I, the lender, have to come and sue you, the borrower, to come and collect my money, I and only I will be the only party to ever be able to recover my attorney's fees, even if you win, so be it. And you agree to that.
Wow, all right.
That's unenforceable.
That's what I thought.
So under 57105, the law says you can write that if you want to.
That's cute.
But they will always
That's nice.
But what's good for the goose?
That's very sweet. But it's not going to work that way. It's always going to be mutual.
Right. You want to play that game? We're going to play that game.
But it's a deterrent, right? To put this in contracts, I would imagine.
Yeah, because how many people who don't practice law necessarily know that?
Right.
And so, it's there to encourage a certain kind of behavior. And as much as it's always, reciprocal, there are exceptions where some courts are not keen to enforce it. Title VII being, I'm not an employment lawyer per se, but, where it's popped up in my cases, defendants can win, but judges are reluctant to then go, pound on the potentially discriminated against person, and now you're going to go pay the attorney's fees for all of that if you in good faith brought your lawsuit. So, but it is reciprocal. And so it is the exception, not the rule. Now, in the course of litigation, I tell clients, I say, there's another way to handle this too. When you come to me and say, we're going to sue under some traditional common law cause of action, misrepresentation, tortious interference with a business relationship, breach of contract that does not include an attorney's fees provision. I said, there is a way as litigation progresses to try to recover your attorney's fees, and that becomes an active deterrent to certain behaviors and becomes a bargaining tool as you get closer to the end of the case, and that's called the formal proposal for settlement. And everyone's like, I know what a settlement is. Yeah, but this is a tool. It's not me sending an email to the other lawyer that says, give me 2 bushels of weed and 6 pizzas and the case is resolved.
And you can have back your cow.
It's a weird formalized, and for law geeks, this was a thing where the Supreme Court, there was this conflict for years, is this a procedural tool or a substantive tool? And it decided it was both. So there's a statute, 768, 79, It talks about the formal proposal, and then Florida Rule of Civil Procedure 1.442 that says this is how you have to do it. And what it is it is a written document, and it says, I am offering settlement to you on the following terms. And you also have to include all of these other things. Does it or does it not include attorney's fees? Does it or does it not resolve anything for punitive damages? And then it has to be transmitted. They have to be given a certain amount of time to respond, 30 days. And if they accept it, then you follow the settlement, the case is done. But if they don't, on that 30th day is when the clock starts ticking. And if you litigate that case all the way to the end, and let's just make up rounded numbers, and you offered $10,000 to resolve the lawsuit, and then the other side wins, but they only recovered $6,000 in attorney's fees, and they didn't come within the 25% margin, they still have to pay your attorney's fees.
Ooh. For failing to settle.
Right.
For wasting all of our time.
Penalty for digging around.
It's you're wasting everybody's time and money.
It's a waste of judicial
And
resources.
This is the fuck around and find out.
It's the fuck around and find out rule.
Fuck around and find out rule. I like that.
And you should have done your homework. You should have properly assessed your case, and there's a price to be paid for that. Now they're pretty strictly construed. Like you make a couple of mistakes and you could be out of court. You also can't offer some ridiculous number.
Right.
You can't offer $5. That's considered a de minimis nonsensical offer. So those don't work. But if it's a good faith number, and I've had them enforced. I mean, they work if you come up with a reasonable number and they don't beat it at trial.
I hate to ask this, but what's a reasonable number? Who determines the reasonable?
It depends.
Number.
Look, every case is different.
Right.
And if
reasonable.
If I offer $10,000 in case A where there's only $50,000 at stake, that's very different than offering $10,000 where $1 million is at stake.
Right.
So, what we often do with clients, particularly at mediation, is, or beforehand actually, we'll sit down and we'll say, what is the real scope of liability? Now we've gone through the pleading, we've managed a good part of the discovery. What are we really looking at so that we can make honest assessments as to what this case is worth? Because I really push to try to get cases mediated early versus later. And then based upon that, if it doesn't settle, we basically just take that number and use that. And either we'll take a little bit off or add a little bit to it. And, that way it also communicates to the other side. Like, we very seriously believe that this is a true number as to what this case should resolve for, and you are now at risk. And it does change the way people play the game. Knowing that you are at risk for the recovery of attorney's fees when you were not it before is a very different way to litigate when you have that in your back pocket.
You mentioned mediation. Kai, how many of your cases would you say actually settle in mediation? Give or take.
So.
And how many times do you regret it?
Well, I mean, so I've never been a part of mediation. It's just not part of what I do at all, and I've thankfully never had to experience one in my personal life. But I can imagine that there are a lot of really angry people with these lawsuits, and I'm not sure how putting them all in the room together somehow magically works, and they all get along, and
They're
kumbaya. There's a
separate rooms. You gotta separate them.
I mean, I this concept is.
It depends on
I'm skeptical.
So it
It's what I'm
depends.
saying.
So it's interesting that you raise it that way
If I'm
because
angry enough to fucking sue you, like, you gotta make me really angry.
well, there's a lot to unpack there. There's a lot to unpack there.
I mean,
So
I'm not a quick trigger when it comes to this, I guess.
No, but
too,
so unlike divorce where,
Sure.
there's a whole other dynamic going on.
There's a whole
Like,
other-
for instance, if you have as much as I'm a business litigator, sometimes these are family members
Sure, yeah.
pounding on each other.
Absolutely.
Those oddly get treated like family law cases at mediation, where you never actually see the other side. So a traditional mediation, in a business litigation mediation before COVID, we would all go down to either somebody's attorney's office, they would come to my office.
I picture it in a conference room.
And we would sit in a conference room. The mediator would sit at the head of the table, and he or she would have the plaintiffs on one side, the defendants on the other, And I've taken the mediation training for circuit court, so, I know the speech. I'm a mediator. This is a confidential discussion. Nothing we talk about will ever leave this room. And I'm here to see if we can't resolve this case today. Because if you don't, you're going to spend money and all of this stuff. And so
yada, yada, yada.
then he or she lets everybody tell their tale of woe. The plaintiffs get to do their opening, the defendants get to do their opening, and everybody's got their own different idea about how that should
area
go.
of the grievances.
Yeah.
This is a Seinfeld, yada,
it is-
yada, yada,
it is,
area
yes.
of the grievances. I'm on a roll. I'm on a roll with the Seinfeld references.
So, in business contexts, the lawyers will always tell their clients, say nothing. Do not turn this into some, I'm right, you're wrong. Like you're never going to go anywhere. You're giving them free testimony.
But do they listen to you?
I've never had a problem. I've been very fortunate that my clients have always.
He has like a
managed
taser.
to-
I was supposed They're like,
It's a cattle prod, but whatever.
I guess maybe I would listen. Like, I'm just putting myself in this position, right? If you were in a lawsuit and you represented me.
Don't ever accept Elina as a client.
I actually am angry enough to go as far as suing you. I'm pissed.
But-
right, like, I want to tell you to fuck off to
Yes,
your face.
and-
Like, she can't wait to get to mediation.
I can't wait.
Fucking wait. Like, brilliant to you. Shove your offer up your ass, Like,
But here's what I do tell clients. So I tell them, I said, look, there are, you watch a lot of TV, you see movies, and they say, I'm going to go to trial and it's my day in court. And I tell them,
Aw, how cute.
I know, isn't that adorable of
Also
you?
so cute.
That's so sweet.
Also so
I go, that's not your day in court, that's my day in court.
You get to sit down and shut
I said, your trial is a beauty pageant. All right? You wear what I tell you. You sit over there. You go twirl the baton when I tell you to. You wear the right colored evening dress and you answer the world peace question the right way. And don't startle anybody too much and we might make it to the top 10. That's what we're hoping for. This is not your day to get on the stand and tell your story. Similarly,
That's right.
your deposition is not your day to tell your story.
But isn't this the
That's right.
foundation of the American legal
Oh,
system? You're
no.
fucking with my idealism, Kai.
We're gonna need another podcast episode. So
Come on.
we need a whole other episode for that. But
Maybe because of what I do for a living, but part of what I do is putting people on the stand to tell their story. Like, there's something to be said for that.
you do get to tell your story. But what you can't do is bring all of your emotions onto the stand with you.
Oh, but who's emotionless if you're suing someone?
Well,
no
you're
one.
not. You're not. But there are, and I tell clients, especially when it's time to get on the
Yeah.
stand for trial or deposition, I said, look, the reason we answer questions in particular ways is it's not like they tell you on TV. I'm not here to be tricky. I'm not here to be cute. We're not here to skirt the truth. We want this to be done in the fastest, most efficient way possible. If we go down some rabbit hole of you being angry or upset, it's only going to lead to more and more and more questions, and we're going to get away from the thing we came into court about. And by the way, you show up to a trial. I mean, I had a 3-day jury trial. We walked into the courtroom. The plaintiff looks at me and says, "Why are we doing a jury trial?" And he's a friend of mine. I said, "I don't know, dumbass. You signed up for this." And he says, I inherited this case from the other lawyers before you inherited your side. I said, "Then why are we standing here?" And the judge looked at us and he says, "Yeah, why are you guys standing here?" He goes, "You guys want to do this on Zoom?" We're like, "Oh yeah." We said, "But I think we're going to need 3 days." He says, "If you're going to do this in non-jury trial," he goes, "I'm getting this done in 8 hours. So be ready." And that's the way it works, which is why we tell clients, you can't just get up there and let it all go. Anyway, now we've completely wandered from the point of mediation.
No.
So-
But this is good.
But at deposition, I tell them, that's not your day. That is the worst day of your case.
Yes.
When you show up, I, as your lawyer, have the least amount of control, authority, and power in the room. All I can say is, objection to form. I can get you still have to answer the question.
That is your cue to think about what the fuck is about to come out of your mouth.
Right. It is. Yeah, that's about right. And then, I can only stop you if you are about to divulge an attorney client, an accountant client, or some physician client, privileged information. other than that, you got to answer the question, even if it's got nothing to do with the case. I mean, there are limitations within reason, of course, but it's not, they get to ask a much broader range of questions than they would. And I just get to sit there and say, objection to form. It's not an ideal environment. And you are going to walk out of your deposition feeling the worst you have felt about your case since the day it was filed. And that's the way they all go. But I tell them at mediation, I go, oh, let your freak flag fly. All you have to do is get through opening, all right? You just sit there and smile. I said, they may say things that are meant to antagonize you. Do not fall for it because they're trying to bait you into a situation. If not, just smile, nod, and then we're gonna go into separate rooms. Now, mediators are really liking the online Zoom thing because we can be all over the world and it's great. We just go into breakout rooms. It's one of the few things I don't love about resolving cases, but that's a different discussion. And the mediator will come in. I said, you can tell the mediator whatever you want. I hate the other person. They're fucking mean.
That's where Lita thrives.
I
want to be sugar.
I'm sorry.
I said, I go, that is
Sugar in the
your
gas
opportunity to tell them whatever you think and feel because that's the mediator's job. The mediator's job is to take all of that and figure out when the mediator goes in the other room.
What the fuck?
And here's the same thing. And
Because everybody's bad shit.
all that bitch wants to do is kill me. I'm gonna fuck her up in court. I'm gonna take all of her money. I don't care them anything. I'm gonna kill their dog. Like all kinds of stuff. And the mediator's job, and I hear mediators talk and they say, oh, well, if everybody leaves unhappy, it's a good settlement. And I don't buy that. A mediator's job is not to get people to like some critical point where it's going to break down. A mediator's job is to find where people's interests overlap and try to create agreement out of that. And it's interesting that as much as people's pleadings will come in a lawsuit from what arguably sound like they're wildly divergent, positions, like I said at the beginning, all lawsuits really are about two things. A disagreement as to what an event means or a misplaced event in time. And when people really start negotiating about those two things, they really find that their interests it's their emotions. That's how they got into this. And it's, once you can start getting people to take that out of the equation, they can start being a lot more reasonable about what they're going to do. Doesn't mean that they all settle. So to answer your question, I would tell you probably half of my cases settle at mediation, but less than 10% of our cases ever go to trial.
Interesting.
So some of them will settle after mediation?
Or before, but
right before trial?
It's funny, it used to be that way. Like there used to be the settlement at the courthouse steps.
Yeah.
I think the way litigation works now, people are so invested in what's going on, it's just so expensive that people are like, well, we've come this far, let's just see what happens.
Yeah, fuck it. Yes. And that's my point. That would be me. That would be me. If I made it that far, like we're fucking here.
But that's what a lot of people do. I last year I tried a case in person and we had gone through all of the evidence. And we'd been there all day. And it was it was boring. Like this is not the kind of thing you'd want to see on TV. There were Excel spreadsheets with numbers and who made what payment, and and to the point that like because it was a non-jury trial, the judge looked at me and goes, "Jacobs, what's that spreadsheet say?" And we would just read out numbers. We're like, we all agree, right? He's like, "I just want to be done with this." And it was going to be very complicated for him to work out a judgment. So he said at the end, "Done. Like this is," he says, "All right, everybody, look, it's 4:50 or whatever time it was." He said, "I'm clearly not going to be able to make a decision about this today." He goes, "I can tell you what my ruling will be." He goes, "But I'm going to send all of you back home to figure out the numbers."
Right.
He said, "So
you guys go start crunching some shit."
He
for
said,
me.
"So here's what I'm going to give you the opportunity to do. You can go take 10 minutes and see if you can resolve this. But you guys have been here all day. I think you know where I'm going to take this." So we all left the room. We all were like, "Forget it. Let's just come up with a number."
We need a number. We need a number.
And all of a sudden, these people who were like, we're not speaking to each other a year and a half ago, you know, now the clients were like, we're not paying these two bozos to go figure this out. Like, how much you got? What are you gonna pay? How fast can we pay? How long is this gonna take?
Oh, that's hilarious.
And they were like, no, 3 months. Let's just be done with this. And here's a check. And you know, it was.
They settled their own case all of a sudden.
And all of a sudden, they came up with their own number.
Wow.
And the other lawyer and I just got to stand there, and I got to, you know, look
Excellent.
at him, and we just, you know, shot the shit for a couple minutes, and you know, because everybody knew what it was going to be. It was just a matter of 10,000 this way or that way. So they came up with their own number. We're like, Judge, we got it done. I was like, excellent. Send me your judgment.
Send me your
And
I love it.
That's, you know, very often how it happens. So, but the idea of it right on the courthouse steps, I've not seen nearly as much of that in the last 6 years or so. But they will settle before calendar call. They
Yeah.
will settle after mediation when people go back and after leaving mediation, because very often people will leave with questions. You know, oh, you know, I should probably look at that better. Because one of the beauties of mediation is the mediator will come in the room and get you to think about things that you weren't thinking about before, because you believe in your position. And your lawyer is paid as much as your lawyer is your
Yeah.
counselor. They're still paid to advocate your position. But a
Right.
neutral person who does not care comes in and says, let me tell you where you got a problem.
Let me tell you, your case is trash. Like,
And
insulting. Very insulting.
and you're like, oh, okay, you know, and I'm a big believer, you know, for you non-litigators, you know, lawyers will spend, you know, weeks fighting about which mediator to use.
Mm-hmm.
Oh, I want this person, I want this person, I want this person, I want to go here. And I tell my clients, I just want to let you know, I will always let the other side pick the mediator. Always. I will go wherever they want to mediate, and I will always let them pick the mediator. And they go, why would you do that? Especially like my clients out of New York and Chicago and Washington, D.C. No, we're going to do it. I said, no, we're going to do it this way. And then they always want to know why. I said, because there is nothing more effective than your hand-picked mediator walking into the room of your office telling you, your case is fucked up. And I'm like, you picked
this
this
is psychology. Like,
I like it.
I find it wildly effective. Wildly effective. You know, when people come and tell me, oh, I've had a lot of success with so-and-so, great, let's use him or her. Great, I'm all for it. I find that to be one of the most effective tools to getting cases resolved.
Interesting.
Very cool.
Interesting.
Very cool.
Yeah, after 3 decades, I've learned a couple things.
Kai, you look like a spring chicken.
Oh, this doesn't just happen.
Oh man. All right. Tell us other stupid shit people do. So you represent business owners, right? It's the title of your damn firm.
Yes.
Okay. So tell us some stupid shit people do.
Stupid shit people do.
What
Other
stupid
than
shit
the
should
suitcase of
people-
cash.
Well,
I mean,
What's that?
the suitcase of cash was.
The suitcase of
You
cash.
What's wrong with a suitcase
wrong with
of
that?
cash?
What's wrong with that?
Well, get your criminal defense lawyer, and he'll tell you why that's a problem.
That's the next podcast.
Yeah, and that's Danny.
He's at two.
Yeah, Danny.
He's at two.
That's a whole. He'll tell you why that's a problem.
I mean, I don't think a suitcase full of cash inherently is an issue, but
Allegedly.
That's different.
Allegedly.
No, but one of the things I see most often business owners do, and that we talked about, is they appoint themselves their own registered agents.
Okay.
And in fairness, it's not that funny.
I can see how this is all gonna go.
Wait, before you keep going, you need to tell our listening
Yes,
audience
what's
what
a
that means. What's a registered agent?
Being a business counselor and lawyer, we represent businesses. Businesses are limited liability companies, corporations, professional associations, and partnerships, limited and all that. So if you are a business entity in any state of this country, you have to have an agent who's designated to receive service of process, meaning when you get sued and the court-appointed process server needs to go deliver these papers, which is still what we do in the 21st century, somebody has to be the designated person to receive those things.
And to be clear, every single business in the United States, no matter what they are, no matter who the owner is, has a registered agent.
Yes.
Okay.
If
so
you
listen,
have-
you're all listening, right?
If you have registered online with the Secretary of State in whatever state you are in this country, you've got a registered agent somewhere. They may give it a different name, but you have a registered agent.
Okay.
So in Florida, They don't, I mean, they give you a little paragraph when you do it online, but nobody reads it. Nobody reads it. Nobody reads the statute as to what it means and what you have to do. And so
I think I'm my registered agent for business. Now that you said that. Go on.
And you start a business, and you don't know anything, which is fair. You're an entrepreneur. You're just getting started. You've got a limited budget. You're already going to pay $125 to the state just to do this thing online, and you didn't stop to think, who's going to do this, and what are the responsibilities? I'm a registered agent. I'm going to get an email once a year to renew my company. I read my email, no problem. I'll type in myself, and that's how I've learned most of my clients approach it.
And get defaulted.
And we'll talk about how that goes sideways. Yes. So then, when you do get sued, everyone's like, "Well, I'm not going to get sued, so it won't be a problem." Those are my favorite clients. Those are my favorite clients.
Well, but I mean, I think I'm going to defend myself here because I think I am my own registered agent. But it's not that you don't think you're going to get sued. It's like, well, I'm the owner. I'm the primary. I'm the person who should receive this.
Correct. That is exactly what every single person believes.
Right. I'm playing devil's advocate.
That is exactly what they believe.
But go on.
And now, you are off on vacation.
Okay,
right?
Sure. Which I do.
Which you do. You will occasionally go on a vacation.
All the time. All the time. It's a miracle. This podcast is not off the ground.
So you are on vacation. You are away.
At the Galapagos.
I am. I'm in the Galapagos.
I mean, she's not like in Orlando.
Okay. And no process server's coming to get you.
In remote areas of the world.
No process server's coming to find you there.
No.
The law says, and it's a fairly lengthy statute, but then if the actual registered agent is not there, there's a list of people in order that they're allowed to go serve.
Okay.
They've got to look for the president, then the vice president, and then invariably.
Which, by the way, the vice president is my husband, who will be in the Galapagos.
Right. So, so you know where it's going to get dumped? With the receptionist.
With the receptionist.
Now, which is fine. Maybe you have the most responsible receptionist in the world. It won't be a problem. Yeah, I know. I couldn't get in. There was nobody at the front desk. So, but then, perhaps, while you're away, your receptionist, I don't feel well. Emergency appendectomy. And then you hire some temp to sit out there. And the temp takes the papers, throws them over there, and forgets about it. Doesn't write down on a sticky note, "Hey, by the way, here's this thing you need to care about." Your receptionist comes back, goes about his or her happy little job. You come back from vacation, you feel awesome. The iguanas didn't eat you. You saw a lot of blue-footed boobies. All is good.
Blue-footed boobies.
What? Anyway.
Watch the National Geographic Channel.
Yeah. They're little birds with bright blue feet. They're kind of this color, actually. The feet.
Yeah, they're like this color.
They're called blue-footed
boobies.
I'm going to Google this later for you. Go on.
We'll show you pictures.
Yeah.
So, you come back, and lo and behold, a month and a half later, this piece of paper shows up on your desk that says there's a judgment entered against the law firm for all of this money. And you say, wait, what? How did that happen?
Okay.
And you go to your lawyer and you say, "Oh my God, Kai, look what happened." And I say, "Why didn't you respond to this?" "I didn't know about it. What do you mean?"
I was in the Galapagos.
And I say, "Well, what? We look it
up.
Well,
who is Michelle Gonzalez? The clown I fired a month ago."
And so, sure enough, Michelle Gonzalez. We're sorry, we don't. Anyway,
hypothetical Michelle Gonzalez.
Allegedly.
Right.
We've lost
this in no way represents an actual person. It's purely a fictional account.
Go on.
Any resemblance to persons living or dead are purely coincidental. So, and I say, well, now there's a judgment. There's nothing you can do. And that's it. And setting aside a default judgment is wild. And by the way, the case law says inattention is not.
Is it really
brutal?
Inattention.
It's fucking brutal.
Once the judgment is entered, and lots of everybody thinks, oh, well, it's excusable neglect, which is one of the most important criteria. And they say the fact that your receptionist left it on the desk and forgot to give it to you is not excusable neglect. And that's bad. So what we encourage everyone to do the second they come on board is switch over your registered agent. We do it. We do it for all of our clients so that we just have process delivered to us. Because one of the most important criteria for being a registered agent is you must be in the premises every business day between 10 and 12. If not, they can go down the list and hunt anybody else down. If the person knows I'm the registered agent and the process server shows up, that is their job. And there's registered agent liability if they screw that up. So that's a whole other problem for the registered agent. But it insulates the business owner.
Right.
And so that's the key. And anyone who thinks that that's not that big a deal, I love to tell my favorite horror story. And I had a client.
I so see myself going back to my office and changing my registered agent in the next 30 minutes. Go on.
I had a client.
To Kai.
Fuck yeah.
Very nice, well-meaning person. He had this vacation condo on South Beach.
Okay.
$770,000 is what he paid. Had a mortgage. And he, being a foreigner living in Colombia, created a domestic entity to own and hold the company so that he didn't have, FIRPTA problems if he went to try to sell it. So he didn't know any differently. He thought he was being, a good business owner. He created a company, it'll be held domestically, and he appointed himself as registered agent, and he said, I'm going to make the property address the registered agent's address.
Of course.
Because then all the mail will come there, it'll be great.
It'll be great.
And he goes back to Colombia after closing, and he says, I'm going to be a responsible property owner. I'm going to put my monthly condominium assessments on auto pay. Does that, and they pay every month. But then after about a year, the condo association raises the rates. And where do they send the notice? To the property address.
Interesting.
Not to him in Colombia. And if you've ever worked with condominium associations, a lot of their stuff is automated. So after a few months, when he's not paying the full amount, well,
they now own this apartment.
it goes to collection. And it goes to the attorneys, who then send out a notice of intent to file a claim of lien. Well, where do they send it? They send it to the property address. Nobody's there to get it. 30 days later, they file a claim of lien. Nobody's there to get it.
Oh, Jesus.
Then they file and sue to foreclose.
Yeah.
They foreclosed on this, and this guy is paying the same amount of money every month.
But who did they serve?
Well, here's the thing. In a foreclosure lawsuit, you can serve by publication if you can't find the registered agent.
Oh, fuck.
And get ready, everybody, because the service of process statutes are going to start changing. They're going to start allowing certain services, believe it or not, by text message and email. So get ready, because it's all going to change.
When is that?
Yeah, well, there's nothing
They
set.
need to do something.
So yeah, they're gonna try to make this a little more in line with the real world, but that's a different conversation. I'm waiting to see how that evolves because I'm really interested.
They need to speed that shit up.
So they can serve by publication. Registered agent, not on site.
Mm-hmm.
No officers, managers, or members for the LLC located. They file affidavits. They file notice to the clerk. Boom, the thing goes published in a newspaper.
Like
And nobody reads.
physical one.
Yes, no, in a physical, the Daily Business Review.
Oh, God.
So do you think that my client in Colombia is thumbing through the Daily Business Review?
Sure. He gets it delivered on his front porch.
Yeah. 8 months after.
Amazing.
So,
Wow.
foreclosed, a judgment of $16,200, and they put the property up on because in foreclosure, the judgment says that the property will be placed for public sale to pay off the debt.
Yes.
So they put it up for sale, and for those of you that don't know, there is a whole group of people out there in Miami-Dade who are pros at this.
Yeah.
They scan these upcoming sales, and they all work it out with each other as to who's going to bid on what for how much. So this property got sold for whatever. Certainly not $770,000. So the guy loses title to pay off the condo association for $16,000 whatever dollars. I think with attorney's fees it was $21,000 by the time it was done.
Oh my God.
But it gets worse.
How?
But it doesn't end there.
But wait, there's more.
Wait, there's more.
Yeah. So the bank that has the mortgage says, "Hey, Mr. Property Owner, you lost the collateral.
You asshole. Like,
That's a default of the mortgage, dumbass. So now we are accelerating the debt Here is your
Oh
notice of
my
acceleration.
God.
Please do us a favor and write us a check for the balance of the loan, which I think at that time was like $685,000. This guy was like beside himself. Like he lands in the U.S. and he's like, "What do you mean?" He goes to his unit.
Where's my Miami Beach apartment?
His property is gone,
Somebody else is living in it.
and they're trying to serve him with this
Crazy.
lawsuit from the bank for the debt.
Crazy.
Had this guy had the correct registered agent, none of this would have happened.
It's pretty bad. This is pretty bad. It's a good story.
That's pretty bad. That's a great story.
It's a good story.
It's terrible.
Well, that's not great for
That's
him.
fucking awful.
Great for
story.
anybody who changes the way they do things because of it, but not for him.
Wow. All right then.
Yeah, that was rough.
Excellent.
I have no words. I need to go fix my registration. Thank you, Kai, for that amazing horror story.
That's what I do.
Well, with that, I think we're just about at the end of our time. So, Kai, thank you so much.
You gotta come
coming
back
out
for another
today.
podcast episode.
You do.
I will
feel
do
like-
this.
I feel like I live vicariously through you guys.
These are
I
great
love
stories.
these stories.
I love these stories. But thank you so much.
Well, thank you for having me.
No problem. Any final words for anyone listening to us? No?
South Florida Business Law Group, we help businesses thrive.
Awesome. And change your registration.
And change your registration, everybody.
Awesome. Thank you so much.
Sure.
Take
Thank
care,
you.
everyone.